Hello and welcome to the Human Rights Regulations and Overview Training for Trainers. This training was designed to provide you, the provider, an overview of the human rights regulations, to assist you, the provider, to better understand your responsibilities and also individuals' rights, and then lastly, to ensure your contextual understanding so that you may use this information presented to train your employees on the human rights regulations. And of course, that's so you can meet the regulatory mandate to provide your staff competency based assessment. So, let's get started. The authority of the Office of Human Rights is documented in the Human Rights Regulations, which is enforced through Virginia Code. The regulations assure specific rights to people receiving services from providers who are either licensed, funded, or operated by the Department of Behavioral Health and Developmental Services, and also require specific actions on the part of providers and Office of Human Rights staff. As such, providers are required to comply with the human rights regulations to include specific provider duties and processes that we'll talk more about throughout this presentation. The best way to access the human rights regulations is through Virginia's Legislative Information System, or the LIS. And for your convenience, the link to our regulations is on the OHR webpage, which can be accessed through the main DBHDS website. So as previously stated, these regulations are enforced through Virginia Code. So in the event that there is non-compliance with regulatory mandates or stipulations, the Office of Human Rights will recommend a citation that will be sent to the Office of Licensing. Citations initiate the documented corrective action process. There are several affirmative rights that individuals receiving services have. When we think about provider compliance, we are primarily looking to ensure assurance of every individual's rights as listed here on the slide and is spelled out in each section of the human rights regulations. In a nutshell, each individual receiving services shall be assured or guaranteed: one, respect for basic human dignity; two, services that are provided consistent with sound therapeutic practice; and then three, protection to exercise their legal, civil, and human rights while they are receiving services. Section 30 of the regulations should be reviewed often. I cannot stress that enough. This section should be reviewed often. It is in this section that you will find relevant definitions of terms and concepts that are critical to your compliance with the regulations. The terms listed here on your screen are not an exhaustive list, but rather represent some of the most important terms to be familiar with in your work in providing services to individuals. So already we've talked a lot about assured rights, or guaranteed rights. Remember, the assured rights of individuals receiving services are the foundation of the human rights regulations. Think of Section 40 as the companion to Section 20. In Section 40, we begin to see provider responsibilities and the effort to assure individuals' rights. Make sure that the rights are posted in the service areas which are most likely to be seen by the individuals. The rights must be presented in the manner that is best understood by individuals you are serving, And the rights that you post must document the name and the phone number for your assigned regional advocate. You also want to make sure that all individuals are notified about their rights in writing at the time of admission and every year thereafter. In notifying the individual of their rights, you must also explain to them how they can file a complaint. In addition, the authorized representative or the AR, if in fact there is one, must also be notified of this information. You also want to make sure the notification of rights contains the individual's and AR's signature and that that document is kept in the individual's services record. You also want to make sure that a copy of the human rights regulations are made available to any individual and AR who asks for them. And then lastly, you want to make sure that information on the Disability Law Center of Virginia is displayed and provided. This is the protection and advocacy agency which the human rights regulations speak of. The purpose of the human rights regulations is to assure or guarantee individuals' human rights. So this includes their right to make complaints for violations of these regulations and to have their complaints resolved. Individuals or their ARs or authorized representatives can also explore legal options. Section 50 is all about dignity. It provides clear do's and don'ts. If you recall, Section 20 stipulates each individual you serve has a right to basic human dignity. In all services, individuals have the right to the following, and we'll discuss restrictions that may be imposed to these rights later on in the training. But as it relates to all individuals receiving all services, they have the right to use their preferred or legal name. They have the right to be protected from harm, which includes abuse, neglect, and exploitation. They have the right to be assisted in learning about or applying for services or benefits for which they are entitled. They have the right to be afforded the opportunity to communicate privately with lawyers, judges, clergy, their authorized representatives, advocates, or DLCV advocates. They also have the right to be informed about program services or program rules and program policies in writing. And lastly, they also have the right to be afforded the opportunity to have a person of their choosing made aware of their status and location. So, some rights specific to individuals receiving residential services include their right to have sufficient and suitable clothing, their right to nutritionally adequate, varied, and appetizing meals which are prepared and served under sanitary conditions. Individuals in residential services have the right to live in a safe, humane, and sanitary environment. Those individuals also have a right to practice a religion and participate in religious services. Residential services individuals also have the right to be provided paper, pencil, and stamps, which are free of charge for at least one letter per day. And that's only if they request it. If the individual, though, is able to purchase their own stamps, their own envelopes, the provider does not have to provide these items. Individuals in residential services also have the right to communicate privately with any person by mail and have help in writing or reading their mail as needed. These individuals also have the right to communicate privately with any person via telephone. And they have the right to have or refuse visitors. Restrictions of certain rights provided for in Section 50 is allowable. However, the human rights regulations document strict procedures in order to implement restrictions, and we'll discuss this more again a bit later. Given the global pandemic that we've all been dealing with since 2020, there have been modifications to the regulations concerning visitation. The Office of Licensing, with the Office of Human Rights, issued a memo concerning this matter back in March of 2020. You may visit the DBHDS website for a copy of this memo and general frequently asked questions related to COVID-19 by visiting www.dbhds.virginia, spelled out, .gov/COVID-19. We are concerned about provider policies being consistent with sound therapeutic practice and their outlined duties as stipulated in Section 60 of the Human Rights Regulations. Generally speaking, documentation in the services record should be relevant to the individual, it should be accurate, and it should be authentic and up to date at all times. Each individual services record should also include an ISP that aligns the service type with the individual's needs and their preferences. And the ISP and discharge plan should be in a clear, understandable language. Remember, individuals must be provided services consistent with sound therapeutic practice. In developing the ISP and discharge plan, it is important that both are written in a manner, again, that is clear and easily understandable for the individual, and that all of the services the individual receives are a part of their ISP. It should go without saying, but make sure that everything that is documented in the services record is authentic, accurate, complete, timely, and pertinent. Section 70 of the regulations speaks to each individual's right to participate meaningfully in decisions regarding all aspects of services affecting that individual. Evidence of consent for services in the individual's record should be in the form of a signed ISP and discharge plan. These plans should contain the signature or other indication of the individual or authorized representative. The signature or mark represents consent as well as the individual's expression and provider's inclusion of preferences to the extent possible. The signatures should precede services which demonstrates that consent occurred prior to service implementation. We'll talk more about capacity and authorized representatives a bit later, but as it relates to this section, the human rights regulations stipulate that based on the individual's capacity, the AR is able to make decisions on the individual's behalf. Providers should also document that the individual has been asked or given the opportunity to express their preferences. This is required to be documented and typically is documented in the ISP. However, this can be documented throughout the services record in other ways according to your policies and procedures. It is important that the individual is encouraged and assisted to be as much a part of their services as they are able to. There are also provisions for services without consent in an emergency and for treatment over objection with a court order. These processes are detailed in Section 70, subsection 5 and 7, respectively. Section 80 of the Human Rights Regulations on confidentiality is an expansive section. It is detailed in your mandates as a provider to ensure and maintain the confidentiality of the individual's identifying information. Key to this section is your responsibility to obtain the individual's and or authorized representatives' authorization prior to the disclosure of any personal identifying information or protected health information. The authorization must be documented and it must be maintained in the individual's services record. Section 90 is about the individual's and AR's right to not only access the individual's services record, but also request amendment to any information which is documented in the services record. Additionally, the individual or AR may allow for certain other people to have access to the individual's record. For those of you providing children's services, understand that parents do not need their child's permission to access their child's services record. However, if the parent's parental rights have been terminated, a court order prevents the parent's access to the record, or the child's treating physician or clinical psychologist has expressed concerns of any contraindications, the parent may not have access to the services record. The child, however, must have their parent's permission to access the services record. The only time access may be granted to the child without the parent's permission is when the record concerns sexually transmitted or other contagious disease, family planning, substance use, mental or emotional treatment, or when the child is at least 14 years old receiving inpatient psychiatric services. Also, individuals have the right to have any amendments that were requested by themselves or the AR, and also their position on any matters in the services record explained to others who are authorized to view their file. The primary responsibility of you as the provider is to inform the individual and their AR of their rights pertaining to their access to and ability to request amendments to the services record. This includes helping the individual to read and fully understand what is documented in the record, and also to request amendment to the record. It is understandable that the information contained in the services record may have certain contraindications. An individual or their AR may be denied access or have access limited to the services record if the treating physician or clinical psychologist determines there are in fact contraindications. There are specific requirements when denying or limiting access to the services record, which are documented in subsection C, 2A through C. You as the provider must investigate any challenges or requests to amend the services record. The specific processes required for this are documented in subsection C 4 A through B. The human rights regulations do not eliminate a provider's ability to impose restrictions. If restrictions are needed to achieve a therapeutic balance between an individual's rights and their health and safety, the provider is able to implement restrictions. However, the process for implementation must be adhered to. When an individual first enters services until the time of their discharge, the individual is entitled to enjoy all freedoms consistent with their need for services, their protection, the protection of others, and those services that do not interfere with their own services or the services of others. Most importantly, individuals are entitled to receive services that are the least restrictive to their freedom. For your reference, the freedoms listed here on your screen are documented in Section 100 of the Human Rights Regulations, specifically subsection A, 1, A through G. Any and all restrictions imposed on individuals must be justified and carried out according to the human rights regulations. Any restriction to an individual's freedoms of everyday life must be assessed by a qualified professional who has been involved in the individual's care prior to the restriction being imposed. Additionally, that qualified professional must, 1, document all possible alternatives to the proposed restriction in the services record. 2, have determined in advance that the proposed restriction is a necessary factor in effectively treating the individual or is a measure of preventing the individual from being harmed, injured, or succumbing to death. 3, have documented the specific reason or reasons for the restriction in the services record. And lastly, 4, have explained and provided in writing to the individual the reason for the restriction, the criteria for removal of the restriction, and the individual's right to a fair review as to whether the restriction is permissible. The qualified professional must also regularly review the restriction and ensure the restriction is discontinued when the predetermined criteria has been met. Qualified professionals are those staff qualified by expertise, training, education, or credentials to perform the specific task or line of service. So, for example, QMHPs, whether they be QMHP-A or QMHP-C, also QMHP-E's or QPP-MHs. And again, these are just some examples. There are several credentials that this applies to. Those were just a few of the examples. Court-ordered restrictions or those required by law must be documented in the individual's services record. It is important to understand that considering the need to implement a restriction is based on the individual's situation. Restrictions should not be thought of as blanket interventions. Also, what is experienced as a restriction for one person may be experienced as a support, a needed support for another. What matters is that providers are engaging in conversations with the individuals and their treatment teams regularly about preferences and needs. Be mindful that you as providers cannot implement a restriction that is in conflict with the human rights regulations. So a common question we receive from providers is, can a legal guardian override a provider and implement a restriction? So the answer to that question is this. As individuals receive services from you, the provider, it is you, the provider, that is actually implementing the restriction. The guardian has the legal authority to ask you, the provider, to implement a restriction, and then you as the provider are compelled to do so by law, assuming that the restriction does not conflict with the individual's human rights and the restriction is carried out according to the processes we've just discussed. While the Office of Human Rights has no regulation over legal guardians, we do, however, of course, regulate you, the provider, as it concerns human rights. Therefore, providers must follow the process outlined within the human rights regulations concerning implementation of restrictions. A key responsibility of the Office of Human Rights is the role we have in facilitating this type of due process as a means of ensuring the rights and protecting the freedoms of individuals in our service delivery system. Specifically in section 100, B as in boy 5, providers are required to obtain approval of the LHRC for any restriction imposed under sections 100 or 50, which is dignity, that lasts longer than 7 days or is imposed 3 or more times during a 30-day period. The restrictions to dignity and freedoms of everyday life request for LHRC review form is an Office of Human Rights process designed to assist you, the provider, to ensure regulatory mandates related to restrictions are in fact followed. Completion of the review form is a requirement and must be correctly completed and thoroughly completed prior to coming before the LHRC. Make sure that you are following up with your assigned regional advocate for access to the review form and also any specific information they may have for you in submitting the form. Upon review of the restrictions, the LHRC will provide recommendations regarding the implementation of the restrictions as it relates to compliance with the human rights regulations, should there be any. The provider is then responsible for adhering to the recommendations and providing updates to the LHRC. The Office of Human Rights acknowledges your experience and expertise as licensed providers. Therefore, it is not our role or the role of the LHRC, rather, to determine whether a restriction is necessary, but to identify whether the restriction is being implemented in accordance with the process as outlined in the human rights regulations. LHRC review of the restrictions may occur after the implementation of the said restriction. However, all restrictions should be discussed with the individual prior to implementation. Moreover, and most importantly, your Office of Human Rights Advocate must be informed of all restrictions. Restrictions to dignity and the reasons for the proposed implementation must be made to the Human Rights Advocate prior to implementation. Again, restrictions to dignity and the reasons for the proposed implementation must be made to the Human Rights Advocate prior to implementation. Should LHRC review occur after implementation of the restrictions, the provider must ensure the restriction is justified and carried out according to sections 50 and or 100 of the Human Rights Regulations. As a reminder, restrictions to dignity are assured rights and are specific. These restrictions, under Section 50 of the Human Rights Regulations, require a specific process to implement. Restrictions to freedoms of everyday life, on the other hand, which are found here in Section 100 of the regulations, are more broad, but they still require a process to implement. So, restrictions to dignity, again, are assured rights, and they are very specific. Restrictions to freedoms of everyday life are more broad. What both of these have in common is they both require specific processes to implement. The dignity section of the regulations, or Section 50, offers procedural context for the implementation of restrictions for the 5 areas listed here on your screen. The need for any restriction of an individual's dignity must first be assessed by a licensed professional. The continuation of the restriction must be reviewed monthly and must be reviewed by the advocate and the LHRC prior to implementation. The initial reason or need for the restriction, along with the licensed professional's assessment, must be documented in the individual's services record along with all subsequent monthly reviews. Also, remember that the individual must be made aware of the proposed restriction and all criteria for length and removal. In all cases, whether considering restrictions under dignity or freedoms, the provider must discuss the restriction with the individual and inform the advocate of the reasons for the restriction. For more in-depth training and more in-depth understanding of restrictions, please visit our training on restraints, behavioral treatment plans, and restrictions that are also posted in this YouTube channel. It is important to understand that program rules are standards of conduct for all individuals within the program. The rules or the expectations should be developed to outline how individuals should behave and interact with each other to maintain order and safety within the program setting. The rules also allow for consequences when rules are broken. As a note, though, consequences should be commensurate to the specific infraction. Each individual must be given a copy of the program rules in a manner that they can best understand them. The rules can also be part of your organization's internal policies and procedures. In developing and enforcing the program rules, providers must be careful not to include rules or expectations that are in conflict with the human rights regulations or in conflict with any individual's ISP. Additionally, the rules should only be developed to maintain safety and order. The regulations also outline what the provider must do in developing these rules, such as 1, involving all individuals who are expected to follow the rules in the creation of the rules. 2, enforcing the rules the same way to each individual. 3, providing the rules to each individual and their authorized representative, if in fact there is one, including an explanation of any consequences. 4, posting the rules in summary form in all areas regularly accessed by individuals and their families. 5, submitting the rules to the LHRC for review upon request by the advocate or the LHRC. And lastly, ensuring individuals are not responsible for disciplining their peers unless there is some sort of self-government program which has been approved by the LHRC prior to implementation and included in your internal policies and procedures. Specific to home and community-based services providers, we acknowledge the potential conflict when attempting to comply with requirements and regulations, particularly related to visitation. Please contact your assigned regional advocate and your DMAS contact responsible for conducting your policy review with any questions or concerns on this matter. You are encouraged to rely on processes for the use of individualized restrictions as opposed to program rules for these potential conflicts. Moving on to section 105. A behavioral treatment plan, or BTP, is a positive tool and resource to assist the individual in reaching their therapeutic goals. The BTP must be carefully developed based on a systematic data collection by a licensed professional or licensed behavior analyst. After the period of data collection, the BTP must include documented procedures for how the plan is to be carried out. The documented procedures are an integral part of the ISP. In other words, the procedures are essential to carrying out the ISP. The human rights regulations allow for providers to use individualized restrictions like restraint and timeout in a behavioral treatment plan. These restrictive interventions should only be used in a BTP to address challenging behaviors that present an immediate danger to the individual or others. Most importantly, as we just discussed, the BTP can only be implemented after a licensed professional or a licensed behavior analyst has conducted a detailed and systematic assessment of the behavior and the situations in which it occurs. So we discussed earlier the credentials necessary to be considered a licensed professional. A licensed behavior analyst is a person licensed by the Board of Medicine to practice behavior analysis. Either a board certified behavior analyst, or BCBA, or a board certified assistant behavior analyst can become a licensed behavior analyst. The licensed professional or licensed behavior analyst is required to conduct the assessment, although they are not required to also write the plan. A qualified professional can develop and implement a restrictive plan, assuming a licensed professional or licensed behavior analyst has conducted the assessment. An independent review committee is appointed or accessed by a provider to review and approve the clinical efficacy of the provider's behavioral treatment plans and associated data collection procedures. An independent review committee shall be composed of professionals with training and experience in behavior analysis and interventions who are not involved in the development of the plan or directly providing services to the individual. Please note that the Office of Human Rights does not have oversight authority or responsibility for the independent review committee. While it may be best practice, only BTPs that contain restraint or timeout require the higher standard of a detailed and systematic assessment by a licensed professional. All restraints identified in the BTP must align with the provider's behavior management program protocol. So in other words, TOVA, MANT, or whatever behavior management your organization subscribes to. If a physical intervention is needed to maintain an individual's safety prior to the independent review committee and or LHRC review, providers may use their emergency response protocols and procedures. Providers that are ICF or IID facilities must submit behavioral treatment plans involving restraint or timeout, along with its independent review committee approval, to the specially constituted committee, or the SCC. All providers must submit behavioral treatment plans involving restraint or timeout, along with their independent review committee approval, to the LHRC prior to implementation. Submission of BTP with restraint or timeout request for LHRC review form is another OHR process. Again, check with your assigned regional advocate for access to the form and any specific instructions they may have for submitting. A very important note: seclusion is not allowed as part of any behavioral treatment plan. First and foremost, only those providers licensed as a children's residential facility or an inpatient hospital or any DBHDS operated facility may use seclusion. Even then, though, these providers must have approved policies prior to their use of seclusion. Section 110 of the Human Rights Regulations provides that all individuals have the right to be completely free from any unnecessary use of seclusion, restraint, or timeout. Note that if any individual requires support to maintain proper body positioning, balance, or alignment, and the individual agrees to use the mechanical support voluntarily, that mechanical support is not considered a restraint. Nor is the use of protective equipment used voluntarily considered a restraint. Please make sure to review the definitions for seclusion, restraint, and timeout in Section 30 of the regulations. Additionally, be mindful that there are certain types of restraints and purposes for their use. Again, a more expansive discussion, a more in-depth overview of restraints, the use of restraints and timeout, can be found in the posted training on restraints, BTPs, and restrictions. So here on your screen are just a few reminders or triggers, if you will, to determine or identify if in fact your use of seclusion, restraint, or timeout is appropriate. One key piece to this is that no restraint should place an individual in a prone position or in a position that places the individual face down. Section 120 concerns individuals' right to be employed by the provider or not be employed. Should an individual be employed by the provider, the work must be consistent with the individual's services needs while receiving services. Activities of personal maintenance are not considered work for those individuals in residential settings. If an individual is employed by the provider cannot require, entice, persuade, or permit the individual to work in exchange for the individual receiving services. All volunteer work must be consistent with the ISP. Additionally, all policies and procedures must adhere to the Fair Labor Standards Act. In considering candidates for employment, individuals receiving services must be considered equally to all other candidates for that employment opportunity. Make sure that all ADA guidelines are followed. Lastly, concerning work, an individual's wages cannot reflect a deduction for the cost of services unless they have been court ordered. Regarding human research, it is important to follow all federal guidelines. Individuals have a right to participate in human research if they so desire, but the individual or their respective AR must provide written informed consent. Additionally, the provider must obtain all IRB approval information from the researcher prior to the individual engaging in any research. To ensure this process is managed properly, the provider must have the research reviewed by the LHRC. Please contact your assigned regional advocate for the human research notification update for LHRC review form, and again, any specific instructions that your assigned regional advocate may have for submitting that form. Section 145 is all about the individual's ability to give consent or authorize the disclosure of information, specifically the individual's capacity or lack thereof. Anytime there is a question whether the individual is able to consent to treatment, services, research, or authorize the disclosure of information, it is the provider's responsibility and duty to obtain a capacity evaluation. In addition, a capacity evaluation must be obtained if or when the individual's condition warrants an evaluation, when the individual requests a review of their capacity, at least every 6 months, and lastly, at the time of discharge. The only time a capacity evaluation does not have to be obtained at discharge is for individuals in an acute inpatient setting. Also, if an individual's capacity is not expected to be regained, the provider must document that the individual's capacity has been reviewed annually. Only licensed professionals who are not involved in the individual's treatment may perform the capacity evaluation. The evaluation must include what types of decisions the individual lacks capacity for specifically. Again, the evaluation must include what types of decisions or what factors is contributing to the individual's lack of capacity. Should the individual or their family member express any objection to the findings of the evaluation, the provider must notify the Office of Human Rights. The objection will need to be reviewed by the LHRC. Please contact your assigned regional advocate for the form and instructions for submission. Special procedures for LHRC hearings regarding consent and authorization are documented in Section 200 of the Human Rights Regulations. This section on authorized representatives is a companion to the previously discussed section on determination of capacity. If an individual lacks capacity, the provider must recognize and obtain consent or authorization for decisions concerning the individual from one, an attorney in fact, or someone who is empowered by a durable power of attorney to consent or authorize disclosure, or from a healthcare agent, someone appointed by the individual under an advance directive or power of attorney, or a legal guardian. And in the case of a minor, this would be the parent. But make sure to adhere to Section 54.1-2969A of the Virginia Code regarding the parent's legal guardianship and any factors that may prevent that parent as serving as a legal guardian. In the event none of these three people exist, so if there is not an attorney in fact, or a healthcare agent, or a legal guardian, the provider must designate a substitute decision maker to serve as the individual's AR. A family member of the individual should be the first to be considered as an AR. Just because the individual lacks capacity, that fact does not forego their ability to express their preferences. So with that, the provider must take into account the preferences of the individual in the designation of an AR. However, if there is no preference, the provider is responsible for picking the best qualified person in the order of priority listed here on your screen. If, for instance, there is no spouse but an adult child, the adult child should be the first person considered. But if the adult child does not appear to be the most qualified person, the provider may choose a parent or adult sibling. Most importantly, the most qualified person must be designated. Should there be no appropriate or qualified family member, the provider may seek to designate a next friend to serve as the AR. This is a person who has shared a residence with the individual or had regular contact with the individual in which significant support was provided. The regulations further stipulate that the next friend must have met these requirements for a 6-month period within 2 years of the designation. Furthermore, the LHRC must review the designation. Providers should contact your assigned regional advocate for the next friend LHRC review form, and again for any specific instructions your assigned regional advocate may have for submitting the form. The proposed next friend is expected to personally appear before the LHRC unless the committee has waived the appearance. Most importantly, the proposed next friend must accept the responsibilities of an AR and agree to act in the individual's best interests and according to the individual's preferences. Any person employed by the provider, including the director, may only serve as an individual's AR for whom they are providing services if that person is the individual's relative or legal guardian. If none of the people we've discussed are available or willing to serve as an authorized representative, the provider must make attempts to identify a suitable person to act as AR. If there are no persons qualified or willing to serve as the individual's AR, the provider may petition the courts to authorize treatment. Section 175. The human rights complaint process is perhaps one of the most important sections of the regulations. It not only documents individuals' rights concerning complaints against their rights, but provides specific procedures for your compliance as providers in guaranteeing or assuring individuals' rights to complain and their protections, as documented here, are fully realized. This slide is specific to complaints against an individual's assured rights. So those rights documented throughout these regulations, specifically in sections 50 through 146. To avoid non-compliance with late reporting, all complaints against assured rights must be reported to the Office of Human Rights no later than the next business day after receipt of the complaint. You must make contact with the individual who is the subject of the complaint regarding the complaint within 24 hours of receipt of the complaint. The investigation of the complaint must begin as soon as possible, but no later than the next business day. The results of the investigation, the director's decision, and any applicable action plan must be documented in CRIS within 10 working days, unless an extension has been granted. Also, the individual and the AR must be made aware of the decision and action plan in writing. Section 175 also provides procedural mandates for complaints involving abuse and neglect. You'll typically hear us refer to these complaints as allegations. It is important to understand that an allegation is not a conclusion of guilt, but rather an assertion of possible wrongdoing. Any action or behavior that has the potential to have been abusive or neglectful must be reported to the Office of Human Rights via CRIS within 24 hours of awareness of the allegation. Additionally, if there's an AR, that person must be notified of the allegation within 24 hours. Any person conducting an investigation of abuse or neglect must be trained to do so. Evidence of training must be documented in the personnel record, and additionally, any person who is the subject of an investigation, despite whether they're trained or not, may not investigate that particular allegation. The regulations stipulate that all investigations should begin as soon as possible. However, Investigations must begin no later than the next business day following receipt of the allegation. The director is the custodian of the investigation. They finalize the investigator's recommendations and any applicable action plan. It is the director's responsibility to inform the individual and AR, if in fact there is one, of the final decision and applicable action plan and their right to appeal and the process to appeal the decision or action plan. This must be in writing and provided within 10 working days of the results of the investigation being submitted. Section 180 outlines the procedures and timelines to be followed when an individual or their AR elects to appeal the director's final decision and or action plan related to the human rights complaint process. The LHRC hearing is not a legal matter. The LHRC conducts informal fact-finding hearings to identify any violations to the regulations. Should either the individual or the provider not agree with the recommendations and findings of the LHRC, either party may appeal to the State Human Rights Committee, or SHRC. The SHRC, however, does not hear any new evidence. Their function is to ensure the LHRC followed regulatory procedures concerning the fact-finding hearing, and that those procedures were adequate. They will also look to determine whether the LHRC findings of fact are wrong. The decision of the SHRC is final. Here in section 220 is all about variances. Variances to the regulations may be approved, but only after you as the provider have completed your due diligence. Any provider seeking a variance to any part of the human rights regulations must submit a formal application which will be accepted and reviewed by the local human rights committee. After such time that the LHRC has reviewed the application for variance, it is then submitted to the SHRC for their review and approval. It's important to note that any variance that is approved has to be reviewed at least annually, and they are only approved for specific time frames or time periods. And once a variance is approved by the SHRC, the provider is expected to follow the approved variance with strict compliance. Specific to complaints involving abuse and neglect, which is section 230 of the Human Rights Regulations, as it relates to reporting on these specific complaints. There you will find specific actions for provider reporting. As previously stated, all allegations of abuse or neglect or exploitation must be reported to the Office of Human Rights via CRIS within 24 hours of receipt of the allegation. Please be advised, all complaints must be reported within the specified time frame, regardless of whether it is a weekend or holiday. So, for example, if a report of A&E or abuse, neglect, and exploitation is received on Friday, at 7 o'clock p.m. It must be entered in CRIS by 7 o'clock p.m. on that next day, which is Saturday. Also, Section 175 of the Human Rights Regulations mandates that investigators of A&E be trained to conduct such investigations, which we discussed previously. For your information, the Office of Human Rights has resources available on the DBHDS website specific to community investigations. The Community Abuse Neglect Investigation Training is also posted on the department's YouTube channel. As with initial reporting timeframes, there are timeframes for beginning and concluding an investigation. Investigations of abuse and neglect must begin as soon as possible, but no later than the next business day. The trained investigator has 10 business days to complete the investigation. Should circumstances arise that prevent the investigator from finishing the investigation on time, the provider may request an extension from the human rights advocate assigned to the case. Extensions, though, will be considered and granted by the advocate for valid reasons. Please be mindful to report any serious injury or death that may be the result of abuse or neglect to the Office of Human Rights within the specified timeframes. Additionally, the Human Rights Regulation stipulates that data on the use of seclusion and restraint also be captured and reported to the Office of Human Rights. This information must be reported to the Office of Human Rights each year by January the 15th. 2021, the Office of Human Rights went to a new system of collecting and receiving the data from licensed providers. And those providers operated by the Department of Behavioral Health and Developmental Services. Please be on the lookout for any information that the office may present to you regarding how you are to submit your information. However, if you have not received any information from the office regarding how to submit your information, please contact your assigned regional advocate, as it is your regulatory responsibility to submit data on seclusion and restraint each year by January 15th. Section 260 of the Human Rights Regulations, which is the last section that we will review in this training, is all about the responsibilities of not only you as the provider, but also the Department of Behavioral Health, specifically the Office of Human Rights. Some of the key parts of this section, and of course this is not an exhaustive list of responsibilities, but some of the key responsibilities are the provider's responsibility to require competency-based training for all staff at the start of their employment and at least every year thereafter. And any documentation, so attendance, any certificates that you may provide, must be maintained in the staff person's personnel file. Providers must comply with the SHRC and the LHRC and any requests made by the Office of Human Rights. Also, you'll see here on your screen, the regulations are documented as stipulating your responsibility to be familiar with the human rights regulations. So therefore, all providers should know where to get the regulations, and they should have general understanding of the regulations. We here at the Office of Human Rights are, of course, here to answer any questions and help provide technical assistance as it relates to your responsibilities in carrying out the regulations. You as a provider are also responsible for ensuring individuals' protection from any abuse and neglect and cooperating with any investigation or hearing or appeal as it relates to any complaints filed on behalf of any individual served. On behalf of the Office of Human Rights, thank you for the work that you do in caring for the individuals within our service delivery system. Should you have any questions, you may contact our Training and Development Coordinator, Carlton Henderson, at carlton.henderson at dbhds.virginia spelled out.gov, or of course, you may contact your assigned regional advocate. Our regional map is located on the OHR webpage for your convenience and review. Again, thank you.